Welcome to today's Employment Standards mini overview on termination notice and termination pay. Thank you for joining us. Before we begin, please be aware of our disclaimer and copyright notice. I'll give you a moment to read it. Basically, we've made every effort to give you the correct information, but if there are any discrepancies between this presentation and the Employment Standards Code, the code will prevail. Please note that the copyright of this presentation belongs to the Government of Alberta. The code provides rules for when termination notice is required and how to calculate termination pay. Employers exploring termination should be aware of the specific provisions for when employment is terminated by an employer. The employer has three options to terminate the employment of an employee. They can provide notice, pay in lieu of notice, or a combination of both. Where termination notice is required, the number of weeks of written notice increases as the employee's years of service increase. As you can see on the slide, employment for 90 days or less does not require any notice by the employer. Going up all the way to 10 years or more of employment with the same employer requires 8 weeks of termination notice from the employer. If termination pay is required, it is calculated by either reviewing what the employee would have ordinarily worked during the notice period, or for employees with irregular schedules, reviewing the average weekly wage of the previous 13 weeks of work. In instances where there is a leave or vacation time before an employment relationship is terminated and the employee did not work those weeks, then those weeks are excluded from the calculation and not counted as part of the 13 weeks of work prior to the termination date. Once termination notice is given, an employee cannot be forced to use any of their entitlements during the remainder of employment. These entitlements include vacation pay, banked overtime, or general holidays banked in lieu but not yet taken. There are many situations where termination notice or pay in lieu of notice is not required. The most common of these is for just cause, as well as seasonal workers, employees who are within 90 calendar days of employment, specific workers in the construction industry, and when unforeseeable or unpreventable circumstances exist and are beyond the control of the employer. If disputes arise regarding termination pay entitlements, the employer is required to provide evidence and support of their position that termination pay was not required. Employment standards will evaluate each situation on a case-by-case basis. The following few slides, we will review different just cause dismissals. Just cause includes, but is not limited to, severe misconduct and repeated behavior ending in termination that has been addressed by progressive discipline. These terms are not defined in employment standards legislation, so this content is for information only and is not intended to be advice. Termination with cause is sometimes referred to as summary dismissal. Just cause termination typically involves conduct that is serious enough either on its own account or in combination with other factors to justify the employer ending the employment relationship. No notice or pay in lieu of notice is required for these types of terminations, and employers can dismiss immediately. When dealing with termination for just cause, it is best, when possible, to seek legal counsel prior to termination. Termination is an instance where keeping complete and accurate records is very important. It is a good practice to document the time, date, and outcome of any conversations or encounters that employers have with their employees about inappropriate behavior or conduct. This information could be useful if the employer decides to end the employment relationship immediately or in the future. As just cause claims are never identical, it is important to examine the case from a holistic, objective view. The following questions may guide employers or an employment standards officer to determine if the employee's conduct was sufficient to warrant dismissal. There is no single answer when it comes to these types of investigations, and all claims of this nature are examined on their own merit. The important thing to note is whether there is sufficient documentation. As always, an employee may speak with a lawyer to provide valuable advice on each situation that may arise. Another important thing to note is that the employer must ensure employees know the consequences of breaking the rules. Employers could develop an employee handbook, which is distributed to all staff. Handbooks may contain specific information on how misconduct or poor performance is handled at the business. And employers must ensure that the guidelines they set out for discipline are followed consistently. Employers can issue warning letters or suspensions if an employee's conduct becomes problematic. Repeated behavior ending in termination that has been addressed by progressive discipline is a stream of just cause dismissal, which typically happens over a number of weeks, months, or even years. The incidences may be minor in nature, but show a pattern of behavior inconsistent with the rules and policies of a workplace. The courts have found that the employer has a duty to warn an employee of problem behavior. The employer is also expected to give the employee reasonable time and assistance in correcting the problem behavior. Essentially, the courts require the employer to prove the following in a just cause case: that a reasonable objective standard of performance was established. The standard was communicated to the employee. The employee was given suitable instruction, assistance, and opportunity to meet the standard. The employee failed to meet the standard. The employee was warned that failure to meet the standard would result in dismissal, and reasonable time was afforded to the employee to correct the situation. Verbal warnings are generally insufficient for a situation where termination of employment is the consequence of further lack of improvement by the employee. It's extremely important to consider the following. Act early, before poor work becomes a habit. Be fair, by clarifying the job expectations with the employee. Improve the employee's performance by providing appropriate direction. And try to solve the problem before it gets to the dismissal stage by applying the progressive discipline process: warnings, training, and suspensions. And that brings us to the end of our mini overview on termination notice and termination pay. If you would like to learn more about various employment standards topics, such as the ones listed on this screen, please scan the QR code to be taken to our website. Also, if you have a question, wish to make a complaint, or submit an anonymous tip to employment standards, please scan the QR code on the screen or call our contact center at 1-877 427 3731. Thank you for viewing today's session on termination notice and termination pay, and we hope you have a pleasant day.